All right. So, welcome to the final panel on regulation and oversight. So we're going to proceed a little bit differently than the previous panels, just in that we don't have PowerPoint slides. And I'm going to give a very brief introduction of each panelist and just proceed from your left to your right, my left, or your right, left, this way. From left to right for you, left to me as well. So I'll start with Jane Bambauer, who is immediately to my left, is a professor of law at the University of Arizona, and her work focuses on the social costs and benefits of big data and questions the wisdom of many well-intentioned privacy laws. And she's published in a number of law reviews, including Stanford Law Review, Michigan Law Review, and California Law Review. And her own data-driven research explores biased judgment, legal education, and legal careers. So we'll hand it over to Jane.
Okay, great. So thanks. It's so nice to have the benefit of all of the excellent presentations that have come before us. And so I think I'm going to go on a slightly different path from the one I originally had thought I might be talking about, but we'll see how it goes. A number of concepts have come up in terms of the types of trade-offs that we might want to make with accuracy in order to achieve some level of fairness, depending on what kind of version of fairness and overall justice you're looking for. Type 1 and type 2 errors are the things that we are accustomed to looking at, and specifically if you're concerned about racially biased outcomes, that's one place where you might want to looking at subgroups. Subgroup, the type 1 error by subgroup tells you something different from just type 1 error in the aggregate, for example. But there is another layer or another dimension that I think ought to be considered, and in some ways, and in some subtle ways, it's come up already, but that's the intensity of the use or even the availability of the use of some algorithm for some purpose where it might not be used for other things. So even with a very low type 1 error, for example, if a technology is deployed or able to be deployed in a way where it can now be used much, much more aggressively over a larger population than it ever could before because costs go down or data is available that never was before or whatnot, then even low rates of error can suddenly have very large impact on the actual experience of people who are subjected to that kind of error. So I've written about this in an article that called Hassle, because I think of that like we have to give that type of error a name, and so I call it, okay, that's the hassle rate. So if suddenly there are a lot of false positives that have to go through an arrest or even just a search, then that's meaningful, even though in relation to the accuracy, it's not so bad. But then there's the other type of, so that's over-intensity. But there's another type of error that can happen that I want to actually explore today, and that's under-intensity, where because data is available in some areas and because it's now so much more efficient to detect certain types of crime, it may leave other areas that are really more important in terms of making people feel secure and cared for by their police. It can leave those under-investigated. And so the kind of prime example that I think helps capture this might be domestic violence. So to give you a sense, I'm sure at least some of these statistics, but it's hard to put a number on these things, but about 1 in 10 kids live in a household that has domestic violence, either between the parents or actually experiences physical violence themselves. And of course, if you count neglect as a form of child abuse, that number goes up. So the home, though, is extremely impenetrable to many of the types of investigatory tools that we're talking about today, at least when we think about predictive policing. And it's becoming more and more so with a court that is becoming more technology-focused in a civil liberties context. And in fact, some of the protection of the home that has been built up with cases like Riley, has actually now The logic of that case has been extended to physical location data as well. So we are getting, in, at least vis-a-vis the government, we're getting more and more privacy when it comes to our physical whereabouts. But that means that some of the crimes that are going to have to rely on old sort of gumshoe style of police detection are going to be the ones that are least transformed by new data-driven algorithms. And those are the ones that, sort of ironically, are the ones that are probably the most important to people in terms of feeling physically secure. So what this suggests is, first of all, there's this kind of paradox where you know, the types of crimes that I think my libertarian and my liberal friends alike would agree are kind of the worst crimes are also increasingly getting more protection and kind of distorting policing, perhaps in a certain way, away from their detection. And the upshot is that I think the insight that this leads me to is that privacy and even the anti-discrimination or algorithmic bias literature that has been developing might be trying to do too much. It may be used as a first resort to try to tackle problems related to you know, abusive uses of power writ large, or to inequality in society writ large, when the tool for that purpose is much too crude. And so that suggests that maybe, so I guess I want to challenge the idea, first of all, that we're living in an era where there is copious amounts of data that can be used for deployment into policing algorithms. I think that as a matter of description, if we think of all the types of information that all humans could possibly be creating, we're still actually pretty weak in terms of the amount of data that's actually collected. And then if we think about where that data tends to be stored and what types it tends to be stored long enough term for police to use it, it tends to be commercial data. So this is like basically all driven by ad tech on the internet, right? And so it tends not to be the most useful data that could be most beneficial for detecting the crimes that we care about. I have other ideas related to kind of trading off accuracy and other forms of fairness, but I'll save that for our discussion.
Okay, thank you very much. So next up is Gary Marchant, who is a Regents Professor of Law and Director of the Center for Law, Science, and Innovation at Arizona State University. Is that right?
Yep.
And his research interests include legal aspects of genomics and personalized medicine, the use of genetic information in environmental regulation, risk and the precautionary principle, and governance of emerging technologies, including artificial intelligence.
Great. Well, thank you for inviting me, and congratulations on the new center here. It's really exciting, and looking forward to what you guys do over the next few years. I think there's a lot of really fun, interesting, and important issues that need to be addressed, including what we're talking about today. So don't really know anything about criminal law, unlike all of you, most of you in this room. So, but I am interested in sort of governance of emerging technologies, and that includes artificial intelligence. I'm very excited about artificial intelligence. I'm very enthusiastic about it. I think we're really at its very early stages, but I think it will be a very powerful tool that's going to help us deal with a lot of major problems, from cancer, climate change, and criminal law and criminal justice. I think there's a lot of problems with our criminal justice system. I think we've relied on humans for a good couple hundred years, and I don't think where we are is very good. So I'm excited. Can artificial intelligence help in this field, or algorithms, or however you want to describe it? I do think it can be helpful. Again, I don't do a lot personally in this area, but I have been working a little bit with the judiciary in our state of Arizona on this, and I think they've done something pretty good. They had a huge problem of pre-trial criminal law, bailment, and so on, where the vast majority of people going to prison before trial are poor, often minority people who can't afford to pay bail. And that's a huge problem. Most of those people are not a risk. But the way our system works is they just go to jail if they can't pay their bail. And so the Supreme Court of our state decided we need to try something better. So they put in place an algorithm. It's certainly not AI or machine learning at this point, but it may be in the future, based on a tool called the Public Safety Assessment, PSA. I think some other states are using that as well. And we don't do anything in sentencing or recidivism or anything like that with any kind of algorithm in our state, but they use it solely in that role, and it seems to be working really well, at least anecdotally from what the judges tell me. Now, one of the problems is they can't afford to do an empirical study that it's working, but it seems like a lot fewer people are going to jail. They haven't had problems of those people not showing up or committing other crimes, very, very low rate of that. And it's saving the state a lot of money from putting these people in jail. And more importantly, it's saving a lot of people who are mostly minority, young people, poor people, from spending several months in jail where it's not a good environment for them to be progressing in their lives. And so to me, I see those kind of examples. I say, yeah, it can really do some good here if it's done right. The problem is some bad uses just a few can really tar a whole technology. And we've seen that across other technologies. It's really easy to lose trust. It's very hard to build trust. And so to me, it has to be governed, and there has to be some governance mechanisms to try to ensure we use this carefully and don't rush to uses that are going to have a backfire and aren't going to do good and cause a huge backlash against the technology. That's not in anyone's interest. So how can we govern this technology? And I guess that's what our panel is about. And to me, in looking at governance of this, I sort of see three issues. So first of all, who should govern? So I think, to me, a congressional or state legislative law on this would be premature and not a good idea. I'm coordinating a project on soft law governance of AI, looking across a lot of different areas, and there's a lot of problems with the traditional way we regulate in terms of things being frozen in place and quickly becoming outdated. So what we're doing in this project is looking at a lot of other mechanisms to use governance for AI across a number of different areas. So what other sort of ways could this be done? I thought the panel number 2 this morning was really interesting, of sort of community boards. But I guess when you think of the criminal justice systems, we have sort of several different levels, right? We have the police, which the community boards might help to address. It seems very promising. Then we have the lawyers, and then we have the judges, and maybe there's others too. None of those seem to be very sophisticated in understanding AI or algorithms, so they're going to need, I think, some guideposts and some guidance. How could that be done? So I haven't done a lot in that area, but I have done some in the judiciary level. So I was in a conference in Europe where they've now adopted a document, a 70-page document, the EU, for judges to use as a guide for using AI in the courts. And they call it, not a manifesto, I forget what the word they use for it is, but it's semi-official. It's officially adopted through the European Union, and it basically has some opening principles and then a really well-written explanation of what these mean. It's very much in a European context, so it's not directly applicable here, but it's, I think, really a helpful guide that judges now in the EU are given as a guidebook of how to use AI in all the different aspects in the courts. In the US, I've participated in a task force created by the National Center for State Courts. It's created a task force to look at AI in the state courts. And we've had these meetings. We're going to have a report coming out, a guide that will go to all the state courts in the country on some principles for using AI in courtrooms. So I think these kind of mechanisms are important and for the courts and judges at least. In terms of prosecutors and police, the community boards for police might be useful, but I think there should be other types of guides or standards or guidelines produced for those groups, from those groups, in order to try to make them work. The next step is, what should those things say? Again, I don't have magical solutions to that. There's all these projects looking at all these soft law mechanisms in AI. The Beckman Center at Harvard just put out the report this week of a number of those. Carlos Gutierrez, who's there in our project, has now identified 500 different mechanisms, soft law mechanisms, and looking at all the principles they have. We haven't asked them yet to look at the ones that apply to criminal justice, but that's coming. And so, which of these would apply to criminal justice? And we've had a great discussion today of some ideas on that. I mean, certainly there has to be some kind of whether you call an ex-ante audit or some kind of test of it or a pilot project, you need to have some reason to believe this has some effectiveness and be useful. I think it has to be better than humans. We've talked a lot about that. I don't think that's sufficient, but that's a necessary condition. Do a lot of work in autonomous cars. There's no way you should have deployed an autonomous car, and that is better than a human-driven car overall. I think that's just a baseline, and all the companies agree with that. That's a baseline requirement you have to get over, but then there's a lot of other things you have to do as well. I think transparency is important. I think that's different than exponentability. I don't think we should require exponentability, but I think we should require transparency. And then some kind of monitoring or auditing function should also be in the substantive requirements. So those are the things I would think right off, and then non-discrimination. To have some way to test for and try to, even if you can't get perfection, reduce the discriminatory impact of our system on minority groups and other underprivileged groups. So those would be the substantive things. And then the final thing would be sort of, how do you enforce these? So that's the purpose of our project, is looking at mechanisms to make soft law effective and trustworthy and credible. And there's all kinds of mechanisms that we're looking at for that, but I'll just punt by saying we're too early in the project to tell the answers.
Okay, thank you very much. So next up is Kenneth Meyer, who is a Deputy District Attorney and the Cannabis Coordinator in the Los Angeles County District Attorney's Office. Kenneth's current work includes managing the use of algorithms and other tools to identify and dismiss pre-Prop 64 cannabis convictions. He previously worked in the geographic information systems field, developing tools for data processing models, geostatistical analysis, and crime analysis. Kenneth.
So I have to start out my discussion that I'm here today not officially representing the DA's office, so my opinions are my own. And I'm going to just go ahead and say I'm skeptical of models, I'm skeptical of algorithms, but I know this is coming. So if you're a California resident, SB 10 was passed in 2018, which basically mandated risk assessment tools over cash bail. That issue was put to a referendum, and that referendum is on the ballot in November. So if you're a California resident, you'll get to vote on that. This has real implications for it's local governments who are going to decide how to implement these things, and it has real implications for how we do justice potentially come November. So it's not just a theoretical discussion for us. So I came here today to learn. I want to say that I work on outlier cases, and I have for the past 12 years, basically. High risk, high danger, murders, large-scale narcotics trafficking. So I'm just going to talk about a few examples and problems that I spot in my work for algorithms. All these things are state action, whether they're the police or whether they're the courts. So they should be regulated and monitored and oversaw. I think, well, when you pass the police stage and move to the court stage, to the accusatory stage, you're implicating a deeper due process. And I think at that point, we really need to start to talk about openness. I think defendants and defense attorneys have a right to see what evaluation is being used against them. And I can't imagine going to court myself and arguing against that. So that, I think it's a non-starter within the court system post-accusatory to do that. We also have ethical duties. I have an ethical duty as a prosecutor, and there's a deeper ethical duty is just to do justice, right? And it's to do justice on individual cases. So when I'm looking at a data model that applies a whole lot of circumstances generally to one person, I still have to look at doing justice for this one person. So there really needs to be a mechanism in court, a mechanism by the judge, where we can do justice on an individual level. So maybe the algorithm and the subjective justice is the worst scenario, from what I gather, but it may be the only scenario that we can have constitutionally if we're going to use algorithms. The other ethical issue, as we move towards evidence-based criminal justice, is that there are a lot of analogous issues to medicine, right? I cannot randomly release or incarcerate people to study them. That's unethical. I cannot deny somebody diversion if we have a diversion program who really deserves it. I cannot deny somebody a rehabilitative program that's available. So randomized control studies are much more complicated in that kind of environment ethically. And they are very analogous to medicine, and there's tools that medicine uses to evaluate statistically that I think would be useful in this sphere. There is tremendous potential to reduce bias, promote fairness, and protect the public at the same time, but there are real risks. Incarceration is a massive cost for society and for the people who are incarcerated and their families. Our getting it wrong also affects the faith in the justice system. It affects my ability to get a witness to court. And just so you guys know, it is much easier to get a witness to court from East LA than it is from Westwood or Brentwood. Just saying. Fundamentally, there's a great quote that I read, Jason Taché. Algorithms are opinions expressed through math. Algorithms are subjective at their heart. They are value assessments of risk. They are not really true automatic. They are not truly accurately measuring risk because of the limitations on them. Some of those limitations are complexity, questionable data, lack of context for the data, assumptions that are made within the algorithm, and algorithms inherently reflect values. Those values, by the way, I think the values should reflect those of the people and the people elected to represent them. So when we have values, they need to be regulated. Some of the problems that I see right away with algorithms is the data's terrible out there. I'll be honest with you, very often, unless it's collected for the study, very often the data's terrible. If I see a rap sheet, I only expect about 80% of convictions to be on a rap sheet. So maybe 85 if they're younger people. So I often will do my own assessments to dig deeper for data. I will check local courts if I know somebody's lived in Riverside or Orange County. So the data's not good. And oftentimes I'm concerned that people who are participants in this process aren't going to understand the tools. And I think the privacy issues that have been talked about are real, but I want us to remember there are rarefied situations where privacy may be a different situation, where we may want to keep secrets in law enforcement legitimately. There are sophisticated criminal organizations that bring narcotics into this country on a large scale. Basically, 5 Mexican cartels control the vast, vast majority of narcotics other than cannabis into this country. So they are very sophisticated, multi-billion-dollar industries and players who are on the watch for what law enforcement is doing, and maybe there's good reasons to keep secrets from them on the tools that are being used. And terrorism is another situation where that might be the case, where we want to keep secrets. And how do we regulate the places where we should keep secrets? Who should have oversight of those, and what is the public input? Context is important. So I was reading criticism of some of the work of the people who've spoken today and others, and I think the criticism is important to listen to, right? Los Angeles County has a bad history of racism, and that's an important context when we look at the data. Policing in LA has a long story and a long history of racism, and it's important context. But that context isn't the only factor that we have to listen to, and it's not. We have to listen to, victims' rights groups, right, and victims on how the models, how our choice to release domestic violence victims impacts them. There's also, when we see differences in groups, it could be actual discrimination going on, but it also could be a deeper question. So criminal history data has problems. Clearly, it has a history of discrimination, but actually, if you look at sex crimes, particularly crimes against children, there is no racial differences among arrest rates for sex crimes, right? There's also very little variability among income groups, right? So there's Jeffrey Epstein's out there, and there are poor people committing the same crimes. That variability changes when it comes to drug sales cases and arrests for drug sales, right? So if you're Hispanic, you're about 3 times more likely to be arrested than a white person. But you're also about 3 times more likely to be poor. So if you normalize the data on arrests of Hispanics and compare them to normalized data of white people, normalizing by income, you'll find that Hispanics are arrested at lower rates than white people for the same drug crimes. It kind of refutes the argument that our immigrants are dangerous. But it also gives us an insight into the data, into the factors that we need to look at, because people who sell drugs are more likely to be poor. And people who live out in the suburbs, who have a house and a job, are less likely to sell drugs. And that shouldn't be, that's not necessarily a reflection of race or discrimination in the data. There's complexity about the facts of the case, and there are outliers. The models in the algorithms will never be able to account for the full complexity of factors that we have to evaluate in a criminal court on whether somebody should be released. So there's a dangerousness test called the static 99 test that's been around since about 1999. And it considers 10 factors of the risk of sex offenders. And most sex crimes prosecutors will roll their eyes a little bit at these because they've already internalized all those factors, and they're much more concerned about fact-specific cases, particularly cases involving sexual violence against children, because those are the really scary people that you don't want released, and they might score a 0. They might score a perfect score still on those cases where we're considering risk. So those rare cases are important. Domestic violence cases, I'm always looking at the facts of the case as opposed to criminal history or appearances in court, right? What I care about in a domestic violence case is the domestic violence offender going to kill their victim. And I care about the risk, and I care about the safety of the victim. And the number of times that a guy, usually, but not always, has beat her up is not determinative of whether he's going to kill her. But the way that a defendant beats up the woman, whether he smacks her face or whether he punches her in the same place over and over again in concealed spots, is very indicative of the controlling, dangerous behavior that is scary and that needs to be kept in custody to keep the victim safe, especially if the victim has left a domestic violence offender and that offender has lost control of the situation, because domestic violence is often about control. Those are very, very difficult factors to factor into an algorithm. I would say impossible with the systems that we have. We have to be concerned about the values we reflect, right? People are more likely to come to court if they have a home, right? And you're very unlikely to come to court if you're homeless. So how do we let our system essentially discriminate against homeless people and keep them in jail longer? And I think that's a value choice that people have to make. And when we regulate, we have to consider those values, and we can't delegate that to a corporation. That absolutely cannot be delegated. I think the algorithms need not just audits. I think we need genuine feedback and feedback loops into our algorithms, right? Can these things learn? They shouldn't learn in machine learning, I don't think so. I think the machine learning can affect bias in the data. And I think at every point where you relearn something, you have to evaluate that with a human being and be checking for bias. But that feedback loop could really improve these over time. Right now, the algorithms, I think, risk assessment in particular, can catch those really low-risk people and kick them out. And they can catch the really high-risk people and kick them out. But there's a great big middle in between where we're still in the subjective evaluation. And we have to preserve judicial discretion in those cases. So on the rare events, how do we deal with sophisticated criminals? Right? How do we deal with the multinational burglars, jewelry thieves who cross into multiple countries? Right? They don't fit into the algorithm. They're not going to have a criminal history in the United States. We're not going to have their criminal history. So we still have to have that, this discretion built into the system. I think there is still a huge space for commercialization and commercial companies and innovation in the algorithms and criminal justice field, even if we have open models, right? You still have a huge need for developing the tools, gathering and integrating data, applying the tools on a case-by-case basis efficiently. And I think there's still a huge space for those tools. In the 1990s, I worked in GIS. We developed those tools, and we developed open tools and sold those tools and made a lot of money selling those tools at the company I worked for. But we were using decision trees, which essentially created analysis algorithms. And in each step along the decision tree, each decision could be evaluated, notated, and then you could add and criticize parts of the tree and create complex analyses in openness, and those can evolve and they can learn. So there's still a huge commercial sphere. I still think the openness needs to be there, absolutely needs to be there in the post-accusatorial side.
Okay, and finally we have Mohammed Tajsar, who is a staff attorney at the ACLU of Southern California. Mohammed's work primarily focuses on national security and counterterrorism policy, with a particular focus on the impacts of national security law on Arab, Muslim, Middle Eastern, and South Asian communities. Mohammed also works on police misconduct, government surveillance, and protecting individuals' and organizations' rights in the digital world.
Thank you so much. Thank you. It's a pleasure to go last, as it were. Let's see. This panel is about sort of oversight and regulation, and what I'd like to offer is that I think that there is an important role that judges can play in this process, in addition to all of the various other regulatory mechanisms that I think Gary was alluding to. And this is because of my thesis here, which is that I think it is impossible to use algorithmic predictive tools in the criminal justice, immigration enforcement, and national security context. And I think that's true for 3 reasons. And so, echoing back to what Andrew was saying in the last panel, I will be the algorithmic abolitionist for today. So I could play that role if you all want me to. So I think that's true for 3 reasons. 2 of the reasons we have already talked about. The first one I think is there's an empirical problem, and I didn't think I would say this today, but I agree with my friend from the DA's office about all of the reasons why I think that's true. I think the second, there are various ethical and political problems associated with the use of these sort of tools and technologies. I think there are problems associated with transparency, sort of local validation, democratic accountability, and there are a whole host of problems here. And I think for me, I would analyze the compare to what problem in a way that I don't think many people today did, which is, for me, the question is not, the compare to what problem would be resolved if we compared to a system in which the levers of criminal justice never engaged in a process of prediction. To me, that is what the ideal state would be. It is not that algorithms are compared to people making predictive judgments. It's that I think we, as the coercive levers of the state, need to divest from prediction, period. And I think that's important. That's what I would say. But I want to offer a third reason why I'm an abolitionist in this context and why I think judges have an important role to play. And that third reason is what I consider to be a legal optimization problem. That is, that I think as a legal matter, it is difficult, in fact impossible, to optimize algorithms for the kinds of things we want to accomplish, right? And so I'm going to give you 2 examples why I think that's true that relate to the work that I do. I work principally on federal law enforcement issues. And I'm going to talk about immigration, I'm going to talk about national security briefly. So, in the immigration enforcement arena, ICE is the principal law enforcement agency. ICE gets its hands on most people through these things called detainers. And ICE has developed really, in some ways, sophisticated mechanisms for analyzing troves of data and determining, using crude algorithms, whether or not somebody is within their jurisdiction, i.e. whether or not somebody is removable. That is, whether somebody is out of status and subject to removal, right? And it has done that essentially through using computerized systems that have basically increased by orders of magnitude the amount of people that come into ICE's custody, ICE's hands. And so the key question for them, for immigration enforcement officers, is who is a removable alien, right? That's what the algorithms that they used tell them automatically. They spit out, using queries of various databases, an answer to that question. But it turns out that question is incredibly difficult to answer. And why is that incredibly difficult to answer? Because the immigration law itself is incredibly complicated. So just the simple question of, are you a citizen, right, turns out to be an incredibly difficult question. Right? For many of us, we're either naturally born or renaturalized, right? That's easy. But there's a whole category of people that are neither naturally born nor did they naturalize, who are citizens. They acquired or derived, in the lexicon of immigration law, citizenship. With that, a principal way of doing that is if you're a child under the age of 18 and your biological parents became citizens. If they naturalized and you were under 18, you, by operation of law, without having to file anything, became a citizen. Okay? So what that means is there are tons of people who, in fact, don't even know that they're citizens because they don't know that their parents naturalized, or indeed, they might not even know their parents. And that's often why you end up hearing in the news many stories of how ICE accidentally detained and arrested and held for months US citizens. It's because ICE itself couldn't figure out whether or not a person was a citizen. And yet they've deployed this massive sort of computer-based system of clicking and arresting people based on an assessment of a person's removability, right? Consider the national security context, right? Who is a national security threat? And so this answer, I think this goes back to some of what Oren was talking about. The answer to this question obviously can have dramatic consequences for individuals. And so just a recent example of why this is important is last year, Judge Trenga in the Eastern District of Virginia invalidated the process whereby the government places people on what's called a terrorist screening database. That is the biggest database of the kind that we're talking about here, and that includes something like 1.2 million people who the government has flagged as a potential national security threat. And so to be placed on this list, a government agency has to make this determination, and I'm going to quote it and ask that you follow along, okay? And then the question I have for you is, after you heard this, tell me whether you think a human can make this determination, and then tell me whether you think a computer can, okay? So to be placed on this watch list, right, of 1.2 million people, a government agency or a foreign government can nominate a person based, quote, upon articulable intelligence or information which, based on the totality of the circumstances, and taken together with rational inferences from those facts, creates a reasonable suspicion that the individual is engaged, has been engaged, or intends to engage in conduct constituting, in preparation for, in aid or in furtherance of, or related to, terrorism and or terrorist activities. All right? So help me out here. What is articulable intelligence? What are rational inferences? What's reasonable suspicion? What are the predicate crimes if they're engaging in or intending to engage in conduct that aids terrorist activities, right? For me, a determination that a person should be on that list based on that standard is impossible for a human to make, right? And I think as a result, it is by definition impossible for an algorithm to make, right? So I think it is, as a legal matter, difficult for us to even allow algorithms to be engaged in these kinds of processes, right? So then where does that leave us, I think? That leaves us in a place where I think you're likely to see much more skepticism from the judicial branch in areas where what I consider to be the vanguard of the deployment of some of these tools, particularly in the federal system. Just last year, I had the privilege of working on a trial team that successfully invalidated on Fourth Amendment grounds that very ICE detention scheme that I was describing. Why? Because the judge ruled that the system that ICE had developed for querying a whole bunch of disparate DHS databases to make removability determinations violates people's Fourth Amendment rights, because that system is inherently unreliable and unlikely to make the kinds of determinations necessary to, the kind of probable cause determination necessary to detain people. And that was just a Fourth Amendment issue. I think there are plenty of due process and confrontation clause issues with a lot of these different areas. And I think you're likely to see, what I hope you will see is as the incentives are set up for the state to continue to use these tools without doing the ex-ante analysis that I think Andrew Ferguson was talking about earlier, you're likely to see much more areas of constitutional infirmity. And in fact, I hope judges will take seriously their duties to perform that kind of scathing, scrutiny of these processes.
Thank you very much. So I have a set of questions, but before I get into those, I wanted to ask if any of the panelists had any reaction or additional comments they wanted to make in light of hearing everybody.
Well, I guess I'll just push back a little bit, Mohammed. I don't see how we can divest from prediction, especially, I mean, I feel like, first of all, just kind of descriptively, I think that boat sailed when Oliver Wendell Holmes said that prediction is everything when you're trying to determine what the law is. But also if we believe that at least part of what we're doing with criminal justice is deterrence and incapacitation, that it seems that prediction is just inherently related. So are you suggesting that we need to change the philosophy?
Yeah. Yes.
Okay,
I mean, I think to me, let's see. I offer this sort of thought experiment, this challenge, which is consider all of the resources that we invest in prediction in the criminal justice system, and then take those resources and channel that into world-class response to criminal activity. Assume for the moment that all of those resources instead are invested in world-class response to criminal activity. What would be the deterrent effect of that kind of world-class response? And is it possible that world-class response to crime after the fact is likely to create the deterrent conditions, if not the better deterrent conditions, than an attempt to predict future crime that creates much of the problems that I think many people here talked about today? That's what I would say.
Okay, all right, any other? So, okay, my first question is, the proprietary issue has come up several times, but we haven't, at least in this conference, really fully engaged with it. So how do we, I mean, I think there's been quite a lot of sentiment, and in fact, I expressed my own sentiment that there's a constitutional due process right to transparency, but that collides, arguably, with the intellectual property rights that the typically private entities that are building these algorithms have. And so how do we, and of course, if they might argue that if forced to open their algorithms to everybody, that would eliminate any ability to gain a competitive advantage versus other companies and thereby be problematic. So any thoughts on how to resolve that tension in light of at least what some people, including me, believe is a real fundamental due process right on the transparency front?
I mean, I think someone said this earlier today, it'd be preferable if we had public sector organizations developing the algorithms. But the reality is that our public sectors are very economically starved right now. Our court systems are struggling to just keep alive with the cutting of budgets and the increased tasks they're actually doing. And so I don't know if that's very realistic, but the one in Arizona was developed by the Arnold Foundation, a nonprofit, and that was great. But I think we're going to rely, particularly if we want these to get better, we're going to have to rely on private companies. And I do think they have a proprietary interest. I used to do drug approvals, and the number one thing you had to fend against is the other drug companies. That's who's trying to get the data all the time. And so there is a legitimate concern with that. But I remember doing cases involving proprietary software, and they're produced to the other side under a protective order. And so I think that's a minimum that should be required, that the other, I think the Loomis case is wrong, that the other side does not get access to the data and to the algorithm and the source code. So I think that's a minimum that they should get access, even if it's under a protective order. But that has limitations. One is, even if you see the data and you see the source code, you still may not be able to predict, why did it predict this kind of sentence for this particular, or risk for this particular individual. That's may not be explainable, particularly as the AI gets more and more complex. And then secondly, it basically doesn't allow other parties to look at that. There's a lot of groups that are doing a lot of good work. I think it was mentioned earlier today, overseeing some of this and being critical of it. And if it's only provided to the litigants in a particular case in a protective order, there wouldn't be that public scrutiny. So those are limitations of that. But I think at a minimum, they should be turned over under a protective order.
Any other thoughts?
Yeah, so I think that there are ways to overcome the problem of inscrutability, especially if we start using more, machine learning, AI-ish sort of stuff through audits and looking for things like, fragility when results rapidly, change significantly with tiny little changes in the input. But I'm still, I'm not convinced that even the due process rules and values that we have are separate and distinct from our concern about accuracy and the kind of distribution of the error when we don't have accuracy. And if you, so you might not agree with me, and maybe I'm just missing something, and that's probably right. But if you believe that a lot of the elaborate structures we have, like Sixth Amendment rights of confrontation, are really about trying to use the tools that we have available to us to really probe whether our system is accurate or not, then it begs the question of what we want, what we want with transparency besides trying to make sure that they are accurate.
Any other thoughts? Okay. So what this next question relates specifically to AI, and I always think of algorithms as a broad class and AI as something within that. In other words, there are algorithms that are not AI, but all AI at any given point in time is executing some sort of algorithm. That's how I think of it. And one of the most potentially powerful and also potentially concerning, in some contexts, aspects of AI is the fact that AI evolves. It teaches itself. The algorithm today may be different from the algorithm yesterday or even 10 minutes ago. And so we have the potential that an algorithm is in some box somewhere, and it's possible that no human being may have ever actually vetted that particular algorithm. And so my question is, although maybe that algorithm is really better than the one that human being originally created. So my question is, in a world where AI is clearly going to be more and more prevalent in the context of criminal justice, does the prospect of algorithms that no human being has ever vetted, should that be completely barred from use in criminal justice context, or how should we think about those things?
My thought was that it has to be, the AI has to be reevaluated. It can't be totally autonomous, because the AI learns bias. And study after study, AI learns bias. It learns the bias from the newspapers that's racial, right? It'll learn bias in the criminal justice system to the degree that it's built into prior history. So AI is going to be biased. So we're going to need human beings to come in and check for that bias and evaluate at every step and at every change. I really do think that. I think that's the only way you can deal with it. You cannot have autonomous AI.
I agree there has to be oversight, but part of our model, the problem is we used to look at things as static. They weren't changing. And so FDA used to regulate medical devices, and they get locked down, they get approved, and they get used in that form for the rest of their useful life. A car software would get approved by NHTSA, locked down, and be used for the rest of its useful life without changing. And now with autonomous cars, that the algorithm's constantly changing, overnight downloads, with medical devices that are constantly being updated, it doesn't fit that model anymore. And I know at the regulatory level, NHTSA and FDA are struggling with that and are trying to think of creative solutions where they're assuming that the algorithm will improve, not get worse, would be the general direction. And so they don't want to stop it. They don't want to stop it and have a 2-year review every week when the algorithm changes. but they also want to have some kind of oversight. And so they're looking at models to be able to constantly be updating. The technology can be updated on its own, but it has to be reported and monitored to the agency. And maybe a similar thing for these type of algorithms, that there has to be, yes, you can update it because they're constantly getting new data and improving, but there has to be some kind of external check on it to make sure it's actually continuing to work as it was supposed to or better.
Thoughts? Okay, we'll get to questions in just a minute. So maybe I'll do one more question, then we'll turn it over to the audience. So discrimination law offers a complex and sometimes contradictory framework for assessing disparate treatment and disparate impact. And to complicate matters further, in the algorithm context, steps to mitigate disparate impact may implicate disparate treatment and vice versa. So for example, if there's a very clear demonstrable racial bias in the data, it might be the ethically correct thing to do to specifically correct for that in the algorithm, but then the algorithm would be indisputably engaging in disparate treatment, which would arguably put it in violation of anti-discrimination law. So the question is, how, do federal anti-discrimination statutes and their interpretations need to be updated in light of this tension in the algorithm context?
Yeah, I think so. I think we have now, or at least in the academy, we have much more sophisticated understanding of what we're trying to get at with anti-discrimination law, thanks in part to people like Andrew. At the same time, though, I do think that that the resistance algorithms tends to overlook that there are lots of examples of algorithms that have Pareto optimal outcomes. And in fact, the counterexamples to algorithms tend to be ones that are from, a private liberal arts college that used its own output variable to predict who's the best candidate to enter. Whereas the things that are most compatible with what we're talking about today, things like recidivism risk scoring, tend to produce outcomes where everyone's better off. There are fewer people being detained before trial, and the race differences between races are at least not exacerbated, and so yes, but also I'm not sure that we're in a crisis yet.
I agree. I too agree that I think there needs to be serious upheaval in certainly in federal anti-discrimination laws, but that's irrespective of the problem of algorithms. There just in general needs to be a rethinking of how discrimination in this society operates, and that are frankly, the conservative pushback against anti-discrimination laws in general has created a situation in which literally nothing is cognizable as discrimination, despite everybody's lived experience and understanding that, in fact, discrimination affects every aspect of what we do and how we operate in our lives. And indeed, that's what makes there was just a Supreme Court oral argument just this month on this question, on but-for causation in hiring of federal contractors and whether or not that meets a certain standard for raising discrimination claims. And so, I think that is true irrespective of the problem of how algorithmic bias can be, of how to adjudicate questions about algorithmic bias in some of these contexts. I think that absolutely, I think everything, all of it needs to be rethought in ways that I think will capture the realities that we all live in today. And I think that the realities that we all live in today increasingly look like there are decisions being made by algorithms and models and computers, or at least assisted by those tools.
Any final comments from any of the panelists? Okay, so we'll end it here. We have a break until 4 o'clock, and then Commissioner Slaughter from the Federal Trade Commission will be speaking to us. And I think there's some refreshments out here, so let's thank the panel.
Thank you so much, Gary. See you.